You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. Understanding the sources of law is fundamental to privacy compliance because every obligation, safeguard, and enforcement mechanism ultimately traces back to one or more of these legal authorities. The U.S. legal system operates within a layered taxonomy that begins with constitutions, extends through statutes and regulations, and is interpreted by courts through precedent. Alongside these public sources, private law instruments, such as contracts, further shape obligations, especially in vendor relationships and cross-border data transfers. For exam candidates, mastering this taxonomy is crucial because questions often test whether you can identify the correct legal source for a particular obligation or determine how conflicts among sources are resolved. Recognizing the hierarchy of authority and the interplay between constitutional principles, statutory mandates, judicial decisions, and contractual terms provides the analytical framework for navigating the fragmented privacy environment in the United States. The U.S. Constitution establishes the supreme law of the land, shaping structural constraints on privacy regulation. Federal authority is limited to enumerated powers, meaning that privacy laws must fall within Congress's constitutional scope, such as interstate commerce. The Constitution also sets boundaries on government intrusion through amendments like the Fourth, which protects against unreasonable searches and seizures. For learners, the key term is supremacy, meaning that constitutional provisions override inconsistent statutes or state actions. On the exam, scenarios may hinge on whether a privacy protection derives from constitutional authority, such as limits on surveillance, or from statutory mandates created by Congress. This foundation clarifies why privacy in the U.S. is fragmented. The Constitution provides certain rights but leaves broad authority for states and federal statutes to fill the gaps. Some state constitutions go further by explicitly recognizing privacy rights. California's Constitution, for example, includes an express right to privacy, which provides a basis for stronger state-level protections. These provisions create independent grounds for litigation and enforcement, separate from federal law. For exam purposes, candidates should remember that while not all states provide explicit privacy rights, those that do can impose heightened obligations on organizations operating within their borders. State constitutional rights may also shape statutory interpretation, influencing how courts evaluate privacy claims. This underscores the importance of recognizing that privacy in the U.S. can be rooted not only in federal principles, but also in distinct state-level constitutional commitments. The Fourth Amendment has been particularly influential in shaping privacy doctrines. Originally focused on physical searches, its principles have been extended to information privacy, especially in cases involving government surveillance and electronic communications. Courts have developed doctrines around reasonable expectations of privacy, requiring warrants for certain types of access. For learners, the Fourth Amendment represents the constitutional anchor for privacy, even though it applies primarily to government actors rather than private entities. On the exam, questions may test recognition of how Fourth Amendment principles influence statutory frameworks like the Electronic Communications Privacy Act, which codifies procedures for lawful surveillance. This illustrates the ripple effect of constitutional protections on broader privacy law. The due process and equal protection clauses also influence privacy adjudication. Substantive due process has been invoked in cases involving personal autonomy and decisional privacy, such as family and medical decisions. Equal protection shapes how privacy laws are applied to different groups, ensuring that rights are not administered in a discriminatory manner. For candidates, the key terms are due process and equal protection, which may appear in scenarios testing recognition of how constitutional principles intersect with privacy. These clauses illustrate that privacy is not only about information, but also about fairness and autonomy in personal decision-making. For exam purposes, they represent broader constitutional contexts that shape how courts interpret privacy disputes. Federal statutes are the primary sources of sector-specific privacy obligations, Laws such as HIPAA, GLBA, CIPPA, and FERPA define duties for organizations within healthcare, finance, children's data, and education. Each statute is tailored to its domain, creating obligations around notice, consent, security, and enforcement. For exam candidates, recognizing which statute applies to which context is essential, as obligations differ dramatically by sector. These statutes demonstrate the sectoral approach of U.S. privacy law, where obligations emerge in piecemeal fashion rather than through a single comprehensive framework. Understanding federal statutes provides the backbone for answering exam questions about compliance in specific industries. State statutes expand the landscape by establishing both comprehensive frameworks and sector-specific rules. California's CCPA and CPRA represent comprehensive state privacy laws, while Illinois' BIPA targets biometric data specifically. These statutes often impose obligations beyond federal requirements, reflecting states' roles as laboratories of innovation. For exam purposes, state statutes are critical because they may apply even when federal laws do not, creating dual compliance obligations. Learners must remember that state privacy laws vary in scope, definitions, and enforcement mechanisms, making them both a source of consumer empowerment and a compliance challenge for organizations operating nationally. Regulations and rules promulgated by agencies operationalize statutory mandates. Agencies such as HHS or the FTC issue detailed requirements, guidance, and enforcement frameworks that specify how organizations must comply. These regulations carry the force of law when issued under statutory authority. For candidates, the key concept is that statutes set broad obligations while regulations provide operational detail. Exam questions may test whether learners can distinguish between statutory requirements and regulatory rules, emphasizing the layered nature of compliance. Understanding this distinction ensures accuracy in applying obligations to specific scenarios. Agency guidance documents and policy statements represent persuasive but non-binding authority. While not legally enforceable in the same way as regulations, they shape organizational expectations and may be cited in enforcement actions as evidence of best practice. For example, FTC staff reports often provide insight into how the agency interprets its Section 5 authority. For learners, recognizing the difference between binding regulations and persuasive guidance is important. On the exam, scenarios may test whether a source is mandatory or advisory, requiring candidates to distinguish legal authority from interpretive influence. Case law and precedent bind interpretations of privacy statutes and constitutional provisions. Courts interpret ambiguous statutory terms, resolve conflicts, and apply constitutional principles to new technologies. For example, Supreme Court cases interpreting the Fourth Amendment in the digital age have reshaped how surveillance is understood. For exam candidates, precedent is a key term. Decisions from higher courts bind lower courts, creating consistent national standards. Exam scenarios may hinge on recognizing whether a principle arises from statutory text or from judicial interpretation. Case law ensures that privacy law evolves dynamically, adapting to new contexts while maintaining continuity. Common law privacy torts provide remedies where statutes may not apply. These include intrusion upon seclusion, appropriation of likeness, public disclosure of private facts, and false light. These torts offer judicially created causes of action that individuals can pursue in civil court. For exam purposes, learners must recognize that common law operates alongside statutory frameworks, providing fallback protections where legislation is silent. These torts highlight the flexibility of the judicial system in addressing privacy harms, ensuring that courts can respond to evolving forms of intrusion even without legislative action. Contracts function as private law instruments that govern data processing obligations between parties. Organizations often commit to privacy and security practices in contracts with vendors, partners, or consumers. For example, business associate agreements under HIPAA, or data processing agreements under state laws, allocate responsibility for safeguarding data. For exam candidates, the key concept is that contracts create enforceable obligations even when statutes do not apply directly. Recognizing contractual obligations as part of the privacy landscape ensures a comprehensive view of compliance. Data processing agreements and addenda are specific contractual mechanisms for managing vendor risk. They require service providers to implement safeguards, restrict data use, and comply with legal obligations. For learners, DPAs illustrate how privacy law extends into supply chains, ensuring that accountability does not stop at organizational boundaries. Exam questions may describe a vendor relationship and test whether a DPA is required. Understanding DPAs ensures candidates can apply privacy obligations effectively in real-world scenarios involving outsourcing and third-party processing. International instruments and transfer frameworks impose external legal constraints on U.S. organizations handling foreign data. Mechanisms such as standard contractual clauses and the EU-US Data Privacy Framework define conditions for lawful cross-border transfers. For exam purposes, these terms demonstrate how privacy compliance is not confined to domestic law, but must account for international obligations. Learners should recognize that global frameworks often drive changes in U.S. practice, as multinational organizations must comply with both domestic and foreign regimes simultaneously. Model laws and uniform acts provide templates for state adoption. The Uniform Law Commission sometimes drafts acts addressing privacy or data security, which states may adopt in whole or in part. For candidates, these sources represent an attempt to harmonize laws across states, reducing fragmentation. Exam scenarios may reference model laws to test whether learners understand their purpose as frameworks rather than binding authority. Recognizing the role of uniform acts highlights how privacy law evolves not only through federal statutes and state innovation, but also through efforts to promote consistency across jurisdictions. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. The hierarchy of authorities is a critical concept for analyzing privacy compliance. At the top sit constitutions, which override inconsistent statutes or regulations. Below them, federal statutes take precedence over conflicting state laws where preemption applies. Regulations issued under statutory authority follow, carrying binding effect as long as they stay within their statutory mandate. Case law interprets these sources and establishes precedent, often resolving ambiguities. Contracts sit lower in the hierarchy but are binding on the parties who sign them, creating enforceable obligations that may exceed statutory minimums. For exam purposes, understanding this hierarchy is key. When conflicts arise, one must identify which authority governs. Learners should remember that while contracts cannot override statutory duties, they can create stricter obligations. This layered structure ensures consistency, while leaving room for flexibility through private agreements and evolving judicial interpretation. Statutory scope and definitions are the starting point for determining applicability. Every law defines the entities it covers, the data it regulates, and the activities it prohibits or requires. For example, HIPAA applies only to covered entities and business associates, while FERPA covers education records. State statutes like the CCPA define covered businesses by revenue thresholds and data volumes. For learners, definitions are often the gatekeepers. Whether information counts as personal data or whether an entity qualifies as a controller determines whether obligations attach. Exam questions may test knowledge of these definitions, emphasizing that accurate interpretation begins not with assumptions but with statutory text. Understanding scope and definitions allows practitioners to assess whether a law applies before considering how to comply. Jurisdiction and choice of law analysis becomes crucial when activities span multiple states or countries. A company based in New York but processing data from California residents must consider whether California's privacy statutes apply. Contracts may contain choice of law clauses specifying which jurisdiction's rules govern disputes, but courts may override these if contrary to public policy. Cross-border transfers further complicate jurisdiction, requiring organizations to comply with both U.S. law and foreign regimes like the GDPR. For exam purposes, candidates should recognize that jurisdiction is not always about where a company is headquartered, but where data subjects reside or where processing occurs. This concept reinforces the principle that privacy obligations follow the data, not just the organization, creating a web of overlapping responsibilities. Preemption analysis determines how federal and state laws interact. When federal law expressly preempts state statutes, state provisions in that domain are invalidated. For example, certain provisions of the Fair Credit Reporting Act explicitly override state rules. Implied preemption occurs when federal regulation is so comprehensive that it leaves no room for state action. However, many privacy laws do not preempt stricter state standards, allowing states to innovate. For exam candidates, the key idea is recognizing when preemption applies and when states retain authority. Scenarios may test whether a state statute survives alongside a federal one. This demonstrates the balance between national uniformity and state experimentation that defines U.S. privacy law. Judicial deference and review standards are essential for understanding how courts evaluate agency interpretations. Historically, Chevron deference required courts to uphold agency interpretations of ambiguous statutes if reasonable. Recent jurisprudence has begun limiting this deference, shifting power back to the judiciary. For privacy law, this means that courts may scrutinize agency rules more closely, potentially narrowing their scope. For learners, the key terms are deference and review. On the exam, questions may test whether candidates recognize the evolving balance between agency expertise and judicial authority. This reinforces the dynamic nature of privacy governance, where enforcement frameworks can shift depending on how courts apply review standards. Canons of statutory construction guide how courts interpret privacy and security provisions. For example, courts may apply the plain meaning rule, giving words their ordinary sense unless defined otherwise. They may also apply the canon against surplusage, avoiding interpretations that render statutory language redundant. In privacy cases, these interpretive rules influence how broadly or narrowly obligations are read. For candidates, recognizing statutory construction ensures that legal interpretation is not arbitrary but guided by established principles. On the exam, scenarios may test whether learners understand how courts resolve ambiguities in statutory language, emphasizing the analytical tools judges use to derive meaning from complex legislative texts. Consent decrees and settlements carry weight as practical compliance signals. While they are not statutes or regulations, they provide valuable insight into how regulators interpret obligations. For example, FTC consent decrees often require companies to implement specific safeguards, signaling what the agency views as reasonable under Section 5 authority. For learners, the key idea is that settlements shape expectations, even though they technically apply only to the parties involved. Exam scenarios may test whether candidates recognize consent decrees as influential but not binding precedent. This underscores how enforcement activity serves as a guidepost for compliance, bridging the gap between abstract rules and concrete practices. Private rights of action expose organizations to litigation risk. When individuals are empowered to sue under privacy statutes, organizations must design controls with potential lawsuits in mind, not just regulatory enforcement. For example, BIPA's private right of action has led to significant class action liability. For candidates, recognizing whether a law grants private enforcement is critical, as it changes the compliance calculus dramatically. On the exam, scenarios may describe a statute and ask whether consumers can enforce it directly. This reinforces that liability risk varies depending on the enforcement structure, with private rights of action creating some of the highest stakes. Contracts provide remedies and allocate risk in privacy incidents. Indemnities shift liability between parties, requiring one party to compensate the other for breaches or violations. For example, a vendor agreement may require the processor to indemnify the controller for regulatory fines resulting from the vendor's misconduct. For learners, the key terms are contractual remedies and indemnities. On the exam, candidates may be tested on whether contracts adequately address privacy risks. In practice, contracts complement statutes by ensuring that accountability flows through business relationships, reducing uncertainty about who bears responsibility when incidents occur. The incorporation of standards and frameworks into contracts is another common practice. Organizations may require vendors to comply with frameworks such as ISO standards, NIST guidelines, or industry codes of conduct. This transforms voluntary frameworks into binding obligations through contract. For candidates, the important idea is that contracts serve as vehicles for importing best practices, making them enforceable as legal duties. Exam scenarios may test whether organizations can use contracts to strengthen compliance beyond statutory baselines. This reflects the hybrid nature of privacy governance, where legal and voluntary frameworks intertwine through contractual commitments. Extraterritorial reach is a growing issue, as state statutes increasingly apply to organizations outside their borders. California's privacy law applies to any business that meets its thresholds and processes data of California residents, regardless of physical location. For exam candidates, extraterritoriality signals that compliance is not confined to where a company operates, but extends to where data subjects live. This concept illustrates how privacy law adapts to a digital economy where borders blur. Scenarios may test whether learners recognize when state laws apply extraterritorially, reinforcing the importance of geographic scope in compliance analysis. Privacy, cybersecurity, and consumer protection regimes frequently overlap. For example, a data breach may trigger privacy notice obligations, cybersecurity safeguard reviews, and consumer protection enforcement for unfair or deceptive practices. For learners, the key term is interplay, emphasizing that incidents often invoke multiple legal regimes simultaneously. Exam scenarios may test whether candidates can identify overlapping obligations and recognize how different regulators may act concurrently. This reinforces the multifaceted nature of compliance, where organizations must prepare for scrutiny under multiple frameworks at once. Record-keeping and documentation serve as evidence of conformity to governing sources. Policies, training logs, risk assessments, and contracts all function as artifacts demonstrating accountability. Regulators and courts increasingly expect organizations to provide this evidence during investigations or litigation. For exam purposes, documentation is a recurring theme. Compliance is not only about doing the right thing, but also about being able to prove it. Scenarios may test whether an organization's documentation practices align with statutory or regulatory requirements. This highlights the operational side of legal compliance, where paper trails are as important as technical safeguards. Continuous monitoring of legal updates is essential for maintaining compliance in a dynamic environment. Privacy law evolves rapidly through new statutes, regulatory changes, and judicial interpretations. Organizations must track these updates, assess their impact, and adjust practices accordingly. For candidates, the key term is monitoring. On the exam, questions may test whether learners recognize the need for ongoing vigilance, rather than one-time compliance. In practice, continuous monitoring is what allows organizations to remain compliant in the face of shifting laws, emerging risks, and evolving interpretations, ensuring that privacy programs remain current and defensible. By mastering the sources of law, learners gain the foundation for both exam reasoning and practical compliance. Constitutions set limits, statutes impose duties, agencies provide detail, courts interpret, and contracts extend obligations into private relationships. Together, these sources form a complex but navigable system, where compliance depends on recognizing authority, scope, and conflict resolution. This mastery equips candidates not only to succeed on the exam, but also to operate effectively as privacy professionals in a world where legal obligations are layered, dynamic, and constantly evolving. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.